everyone, I am Anshika and today I am going to discuss the concept of strict liability. So, what is strict liability? Strict liability is the principle which evolved from the case of Reliance versus Fletcher in the year 1968. This principle clearly states that the person who keeps hazardous substance in his premises is responsible for the fault if that substance escapes in any manner and causes damages. This principle stands true if there is no negligence on the side of the person keeping it, and the burden of proof always lies on the defendant to prove how he is not liable. According to the rule set by this case, if a person brings on his land and keeps there any dangerous thing, a thing which is likely to do mischief, if it escapes, he will be prima facie answerable to the damage caused by his escape, even though he had not been negligent in keeping it there. The liability arises not because there was any fault or negligence on the part of a person, but because he kept some dangerous thing on the land and same has escaped from there and caused damage. Since in such a case the liability arises even without any negligence on the part of the defendant, it is known as a rule of strict liability. So now we'll discuss the case of Reliance versus Fletcher. So the brief facts of the case are: there were two men living next to each other, Reliance and Fletcher. Fletcher owned a mill for energy requirement. For whose energy requirement he constructed a water reservoir in his land. To get his work done, he had hired independent contractors and engineers. There were old unused shafts under the site of the reservoir which the engineers didn't notice and thus did not block them. Due to the negligence of the contractors, the shafts that led way to Reliance's land burst when the water was filled in the reservoir. This caused huge damage and loss to Reliance as the water entered in his coal mine. Thus, Reliance filed a suit against Fletcher. So, the issue held in this case was whether the defendant to be held liable for the act of someone else due to which an entity on his land escapes without his negligence or intention. So this rule of strict liability says a person who keeps hazardous substance in his premises is responsible for the fault if that substance escapes in any manner and causes damages. So the contention in this case was the defendant took the defense that it was not his fault but of the contractor, he being liable for the damage the cause of which was unknown to him, was not acceptable to him. So in this case, the judgment was like that: the House of the Lords rejected the plea of the defendant and claimed him to be liable for all the damages to Reliance. Sir Lord Keynes, on the other hand, said that if the defendants, not stopping at the natural use of the clothes, had desired to use it for any purpose which I may term a non-natural use, for the purpose of introducing into the clothes that which in its natural condition was not in or upon it, for the purpose of introducing water either above or below ground in quantities and in a manner not the result of any work or operation or on under the land, and if in consequence of their doing so or in consequence of any imperfection in the mode of their doing so, the water came to escape and to pass off into the clothes of the plaintiff, then it appears to me that which the defendant were doing, they were doing at their own peril, and if the course of their doing it, the evil arose to which I have referred, the evil namely of the escape of water and its passing away to the clothes of plaintiff and injuring the plaintiff, then for the consequence of that, in my opinion, the defendants would be liable. So to summarize this above rule, Justice Blackburn said that if the person who for its own purpose brings on his land and collects there anything likely to do mischief, it escapes, must keep it as his peril, and he does not do so, he is prima facie answerable for all the damage which is natural consequence of its escape, though he had not been negligent. Therefore, this is one of the most important landmark judgments in the history of the legal system, since it led to the formulation of a new concept, a new idea, and thus a new principle, the rule of strict liability. Based upon this principle, there were certain qualifications given to decide whether a liability is strict liability or not. Only after these essential qualifications being satisfied, a liability can be termed as strict liability. So, what are the essentials of strict liability? Number 1 is dangerous substances. The defendant will be held strictly liable only if the dangerous substances escapes from his premises. For the purpose of imposing strict liability, a dangerous substance can be defined as any substance which will cause some mischief or harm if it escapes. Things like explosives, toxic gases, electricity, etc. can be termed as dangerous things. Second one is escape. One more essential condition to make the defendant strictly liable is that the material should escape from the premises and shouldn't be within the reach of the defendant after its escape. For instance, the defendant has some poisonous plant on his property. Leaves from the plant enter the property of the plaintiff and is eaten by his cattle, who as a result die. The defendant will be liable for the loss. But on the other hand, if the cattle belonging to the plaintiff entered the premises of the defendant and eats the poisonous leaves and die, the defendant would not be liable. In the judicial pronouncement of Reeds versus LEXIS and Company, it was held that if there is no escape, the defendant cannot be held liable. Third essential is non-natural use. To constitute a strict liability, there should be a non-natural use of land. In the case of Land versus Fletcher, water collected in the reservoir was considered to be a non-natural use of land. Storage of water for domestic use is considered to be natural use. But storing of water for the purpose of energizing a mill was considered non-natural by the court. When the term non-natural is to be considered, it should be kept in mind that there must be some special use which increases the danger to others. Supply of cooking gas through the pipeline, electric wiring in a house, etc. is considered to be the natural use of land. For instance, if the defendant lights up a fire in his fireplace and spark escapes and causes a fire, the defendant will not be held liable as it was a natural use of land. These three conditions need to be satisfied simultaneously to constitute a strict liability. So here are the exceptions to the rule of strict liability. There is number 1, plaintiff's fault. If the plaintiff is at fault and any change and any damage is caused, the defendant would not be held liable, as the plaintiff himself came in contact with the dangerous thing. Second one is act of God. The phrase act of God can be defined as an event which is beyond the control of any human agency. Such acts happen exclusively due to natural reasons and cannot be prevented even while exercising caution and foresight. The defendant won't be liable for the loss if the dangerous substance escaped because of some unforeseen and natural event which couldn't be have controlled in any manner. Third exception is act of the third party. The rule also doesn't apply when the damage is caused due to the act of a third party. The third party means that a person is neither the servant of the defendant nor the defendant has any contact with them or control over his work. But where the acts of the third party can be foreseen, the defendant must take due care. Otherwise, he will be held responsible. And the last exception is consent of the plaintiff. This exception follows the principle of the voluntary non-fit injuria. For instance, if A and B are neighbors and they share the same water source which is situated on the land of A, and if the water escapes and causes damage to B, he can't claim damages as A won't be liable for the damage. in a case of State of Punjab versus Messrs. Modern Cultivators, Supreme Court expressly held that India is an agricultural based country, so to store water on land is not considered unnatural use of land. Supreme Court held that in India, the general rule in Rillen versus Fletcher is accepted, though in some cases the principle in the case was considered to be modified in application to the Indian conditions. So I think the concept of strict liability is clear to all. In case of any doubt, do mention in the comment box. Thank you. Bye bye.